Good evening, everyone. My name is Sue Fager with Pacer Center. While we wait for everyone to join our webinar this evening, if you'd like to make use of the Q&A box and share your name, where you're joining us from, and how old your student, young adult, or adult is. We'll wait a couple minutes for everyone to join us. Joe, looks like we've got folks from Rochester, Humble, Texas, Waconia, New Jersey, St. Paul, St. Cloud, Ohio. Looks like we've got folks who are transition age and young adults so far.
Okay.
Well, I think we'll go ahead and get started. Welcome, everyone. My name is Sue Fager. I'm the Transition to Adulthood Project Coordinator with Pacer Center. For those of you who aren't familiar with Pacer Center, we are Minnesota's parent training and information center. Every state and territory in the union has a PTI. We support families and young adults to navigate both special education services and also planning for and accessing adult services once they complete their special education and transition services. I have included a link to the website, so you can just click on that link if you would like to learn more about Pacer and all the different services we offer. Our main presenter tonight will be Joe Kukla. He is an attorney with Thiel, Anderson, Kukla, and Gunderson. And I have just a couple slides to share, and then we'll be turning it over to Joe. Hang on while I advance my slide.
So I think if you just click somewhere in the PowerPoint, yeah.
Got it. Thank you. So planning for the age of majority and young adulthood, transferring educational and other decision-making that happens at age 18. For Special Education Law, or IDEA, the Individuals with Disabilities Education Act, the legislation gives states the authority to transfer educational decision-making rights to students who are receiving special education services. That happens at age 18, which is known as the age of majority because students are no longer considered minors. So we hear a lot from families whose students are turning 17 and they are getting notices from the school that their students are about a year away from the age of majority and they need to start thinking about guardianship and or supported decision-making. We also hear from families whose doctors and other healthcare professionals are reminding them of the same, that everything changes when your student turns 18. So the transfer of rights includes, in addition to the right to make decisions about their education, young adults have the right to vote, to consent to medical treatments, the right to marry, and the right to sign contracts. Some of these issues can be a little scary for parents and family members to think about as they think about their young adult. We are not going to spend much time tonight on the age of majority and the transfer of rights because the focus of Joe's presentation is the guardianship process and how to navigate it. I would, though, like to let parents and any students or young adults who are joining us tonight that a student can choose, once they reach the age of 18, to invite to their IEP meetings and to be part of their IEP decision-making process, parents, family members, other adults. So it's not, oh, they're going to turn 18 and you have to get a guardianship kind of decision. There are some options, but we want you to have lots of information so you can make your own supported decision in accordance with your young adult. We've included a couple more resources that didn't make it into the resource list that Jamie sent to you previously. I think I got my list again this morning. Great resource. We'd like to let all of you know about folks who live in Minnesota. We have what's called the Disability Hub, ton of information, lots of supports available. Parents, families, adults, young adults can reach out to the hub with questions they have about disability services and navigating them. The hub has a great video on guardianship as well. So we are, let's see, the order of things for tonight, before I turn it over to Joe, we would like you to post your questions in the Q&A. Jamie, my colleague, who on your screen is called Pacer Center, Jamie will be posting resources in the chat field. So again, use the Q&A field for your questions. Joe and I will be fielding those questions after every slide. So with that, I'm going to stop sharing my screen and turn it over to Joe. Thanks, everyone.
All right, thank you, Sue. There we go. I think my slides are up now. Is that right?
Perfect.
Good, good. Yeah, and so before we get started, I'll just give everybody a little bit of background about myself and about our firm and what we do. I've been practicing for about 18 years now, all in Minnesota. I grew up here, but went away to school and came back, and have been working for this firm, Thiel, now Kukla and Gunderson, since 2013. The reason why I work here, it's a boutique firm, small firm with limited partnership, limited staff, but we focus on working with people who have family members or children with disabilities. And my interest here is because my youngest brother has developmental disabilities, intellectual disabilities. And when he turned 18, he's 8 years younger than I am. He's the youngest of three of us. When he turned 18, my parents sought guardianship and used this firm. Obviously, I wasn't here yet. I was actually still in law school at the time, but their pursuit of guardianship and then ultimately doing their estate plan with the trust, and dealing with SSI and medical assistance really sort of got me interested in all of the legal aspects, the details of what they had to go through, and also in no small part so that I would be prepared to take over, so to speak, and to handle things for my brother in case something happened to my parents. Luckily, they have aged well and they are still the guardians, but I am still the successor in waiting. My brother is now 37 years old. He lives in a group home here in the cities. It's actually in Wayzata, and gets all of his services through Opportunity Partners and Hammer. But when he was younger, he certainly took advantage of, and my folks did too, of taking advantage of the services that Pacer offered. We as a firm here have been doing presentations and workshops and webinars for Pacer going back many years. And so this is something we do on a regular basis and find that it's really helpful to parents, especially, but certainly to family members, as their children or their family member is approaching age 18, to understand what guardianship is all about. And I think the best way to do that is to look at it from the perspective of what does guardianship mean under Minnesota state law? What are the aspects of the guardianship and the authority that it's given or that it gives to the legal guardians? And what is the procedure to have guardians appointed for a person? I think the strategy of looking at it from that perspective helps people make a informed decision about whether guardianship is going to be appropriate or not, because we certainly talk about alternatives and we refer to those as less restrictive alternatives. The way that we practice, the way that we approach things is that guardianship is sort of maybe last resort is not the correct term, but we do explore all alternatives before making a decision to go forward with guardianship. And I think the way that we do that, I think the best way to approach it and make sure that we're making a good decision and advising parents and family members properly is to go through the statutory powers that guardianship provides and evaluate those individually to determine whether it's appropriate or whether there's something that something less restrictive that we can pursue. So I think what I will do here, let's see if I can get, oh, I don't know. There we go. So I was having trouble switching the slide. But Sue mentioned just briefly at the end there before I was introduced, you know, I'm used to doing a lot of these presentations live. I certainly, my personal preference is to be in front of a room and seeing reactions and responding to people directly with questions. Of course, I can't see any of you doing it as a webinar. There are certainly advantages to this. We can reach people easier and it's a lot easier for you guys to attend. But in the interest of sort of keeping the discussion rolling, I'm going to go through the slides and then we're going to stop and try and answer questions about each of these topics or each slide as we go through. And that, to me, it just seems like it keeps the conversation a little bit more lively. So we'll start here and we'll sort of break for questions. So post them or send them in as you have them. So again, you know, the idea of guardianship, you know, starts first with, you know, why are we here? Why do we even consider it? And it starts with a person being identified with having an incapacity. And in legal terms, what an incapacity means is they're not able for some intellectual or cognitive reason to make informed decisions about their own personal care, about the critical aspects of life. So it's when you're under the age of 18, the law declares that that is your incapacity. as a minor person, you lack the legal capacity to make critical life decisions independently. So you are naturally under guardianship of your parents, if, of course, they're in most cases. But once a person turns 18, regardless of diagnosis or regardless of what everybody knows, they are automatically granted all of the legal individual rights that the rest of us have, just by virtue of becoming an adult. These are the constitutional rights. This is the way our world works here, our country and state works. And so the idea of protecting a person after they turn 18 and pursuing guardianship is because you are declaring that they lack the capacity as an adult to make critical life decisions. We talk about this, a lot, kind of somewhat jokingly, but I think it holds true. Quite a lot of people at age 18, 19, 20 are not ready to make critical life decisions on their own. They still rely on parents or rely on family or um, rely on some kind of support to help them understand how to become adults. And so that's not necessarily what we're talking about here, of course. What we're talking about is a person who, because of a diagnosis, because of a specific cognitive issue, uh, does not have the ability to sort of um, act with uh, the ability to make those decisions. But ultimately, the idea is that they cannot be responsible for those decisions as well. They sort of lack the capacity to understand the consequences or the significance of the critical life decisions that they are making. Much like a minor child, a 10-year-old or an 11-year-old. And so we seek to have a legal guardian appointed to continue supervising and making those legal decisions for them, or those life decisions for them as adults. Sue mentioned the age of majority. Of course, that's the trigger point, age 18 in Minnesota, and in pretty much the rest of the country says that at age 18 is when you are granted those individual rights automatically by the Constitution. To have those rights restricted or reserved by a guardian, you do have to go through the court process to declare why this person lacks the capacity to be responsible and make choices for themselves as a responsible adult. And then just briefly, I'd like to mention before we get into the specifics of guardianship that there are two terms at play here. For those of you in other states, this may not be consistent, but in Minnesota, we refer to guardianship as being or as having the authority to make decisions about the person. So as we go through these slides, I'll explain, of course, more about what that means. But conservatorship is about handling money. We call it conservatorship of the estate. It should be noted that in Minnesota, and we are in the minority for this among the 50 states, but in Minnesota, the guardianship statute does not give any legal authority to a person to manage assets. You are not granted with the authority to manage bank accounts. You are not granted with the authority to, I guess, manage like personal property beyond tangible items, which again, I'll explain further. But if a person does have substantial personal assets, such as a bank account, they've maybe received an inheritance in the past or gifts in the past, then you may need to consider conservatorship as well as guardianship in Minnesota. but primarily conservatorship is going to be reserved more for people who have accumulated assets and then become incapacitated later in life. So a lot of times that'll be an older person who has suffered an accident and had a traumatic brain injury. It may be somebody who's suffering from dementia, who hasn't been able to set up a trust or a power of attorney, giving somebody else the authority to manage assets. But with guardianship, none of those things are dealt with, and so for most people at age 18, they don't have any personal assets, and so it is not terribly common. I would say it's even rare for us to pursue conservatorship for an 18-year-old. So we're not going to talk extensively about that tonight, but I will explain what limited financial powers a guardian does receive under Minnesota state law. And you may realize that that is sufficient given the circumstances of an 18 or 19-year-old person, or even a little bit of an older young adult. So when we meet with people, when I'm approached and somebody wants to talk about guardianship, and they start with, is guardianship going to be appropriate for my son or daughter? I think the best way, at least for me, at least the way that I've found to evaluate whether guardianship is going to be appropriate, is to look at the statute itself and look at the isolated powers that the court gives to a legal guardian. And when we petition for guardianship, we can ask for all or just some of these powers. And if any of them seem to be necessary, then we pursue the petition and we pursue the appointment. Some of these can be alleviated. In fact, most of them, again, with less restrictive alternatives, such as a healthcare directive and a financial power of attorney, if a person is capable of understanding what they are signing and giving their consent to that authority. But if a person is incapable, the way that we determine their capacity, whether they are capable or not, is by breaking down each of these individual powers and understanding what they are able to do. So I'll just explain a little bit about what each of these mean. Of course, what I have here on the slide is an abbreviated version of what the statute says, and it goes into further detail. But the point here, I guess, too, is that if we are going to pursue guardianship with the court, the district court that we petition is holding us to a burden of proof. And meeting that burden of proof means establishing that the individual who is the person subject to guardianship is not capable of exercising each of these powers, so to speak, on their own. And so when we file a petition in Hennepin County, for example, the expectation, even if there's not an objection to that petition from anybody else in the family, is that we're going to establish that each of the powers that we're seeking for the guardian is appropriate to basically have those powers taken from the individual who is the subject of the guardianship and given to the legal guardian out of respect for their vulnerability and protection where they may be exploited. So the first power that we look at is establishing a place of abode. And because this is statutory language, it's just a little bit more archaic like that. But it's really, what that means is, where is this person going to live? And the question we ask is, starting out, from the perspective of, say, mom and dad seeking guardianship, does your child still live with you in your home? And going to that second power there, it's in your home, are you able to provide for that person's care, comfort, and maintenance needs? And then we sort of ask, well, okay, that's great. A lot of people still live at home at age 18, age 19, heck, even age 27, 28, possibly. But the question that we look at is, if the circumstances arise where the person would need to move to a new residence, would they be reasonably capable of finding a place to live, a safe place to live on their own without any help? And again, not talking about, when you're helping a 19-year-old find an apartment. Of course, they might ask mom or dad to help them hunt for the right place and determine what they can afford and all of that. It's more of a question about, okay, let's remove the mom and dad from the equation. Let's assume that they're not available. Let's assume that there's nobody else that can help them. Would they be capable of identifying a place to live and understanding how to sign a lease agreement, how to move to that residence? If not, a legal guardian might have to have that authority to establish where the person lives. Of course, a person under guardianship still has input into that decision, which is something that I'm going to expand upon later. But again, we get into the second power, and this is a little bit more general. A person, in that home, can the guardian provide for that person's care, comfort, and maintenance needs? The third one is one we look at a little bit more closely, especially if we have a person who is higher functioning, more capable of independence, and it's taking reasonable care of personal property. Of course, a person who has an intellectual disability can certainly still have their own stuff. They still have their clothing, they still have personal belongings that they would consider theirs, like an iPad or an Xbox or books or art materials or anything like that. They may consider it their own, and rightly so. But the question here is about whether a guardian needs to be appointed with this power to take ultimate responsibility for that property. And what we're evaluating is this person capable of understanding and appreciating the value of their personal possessions? Would they be vulnerable potentially to somebody taking advantage of them? Say, they have a friend over at the house who says, I'll give you $5 for your brand new Xbox. Would some, person who has an intellectual disability just hand over their Xbox and say, sure, that sounds good? So yeah, it's the idea of, ultimately, does the guardian need to take need to take responsibility for the personal property, not only in maintaining it, but also in potentially disposing of it, selling it or transferring it to somebody else. The fourth power is oftentimes the most critical and sort of the tipping point as to why or whether or not we need to appoint guardians. And it's giving consent to medical or other professional care. And why I say it's often the tipping point is because you may have a pediatrician or a primary care doctor who has known the individual for some time, or has at least evaluated them. This can also be like a specialist, like possibly a neurologist, physical therapist even, who warns you that when your child turns 18, HIPAA rules kick in and their privacy rights kick in, and that prevents the doctor from sharing information with mom and dad, because the way that they see it is potentially that the individual who has an intellectual disability lacks the ability to give legal consent to anybody else to see their medical records or make decisions on their behalf. Therefore, the guardianship becomes necessary to give the guardians the legal authority, just as if they are, exercising legal authority again over a minor child, like a 10-year-old, to see that person's medical records and ultimately be the decision maker. Otherwise, doctors and other professionals may be restricted by their licensing, um, and worried about a HIPAA violation where they could potentially be held liable for disclosing information to somebody that was supposed to be kept private. Now, that's the legal sort of version of it. In reality, if the doctor has known the family for a while, has known the parents, has known this individual, they might feel like there's not much of a risk to their liability and they may let things slide. And so I hear from parents all the time, well, my child is 25 years old and I've still been going to the doctor and making all of his decisions for him. And I said, well, yeah, that can happen. That's up to the doctor, though, to decide whether they're going to let that slide, because the letter of the law says that at age 18, they're no longer supposed to disclose any information or talk to anybody other than the patient themselves. So it's something that if you encounter it, where a doctor is going to resist providing you information, they're probably going to inform you of that as your child is reaching age 18. And then that will indicate pretty strongly whether you need to pursue guardianship or not. Um, the next one I have on here is exercising supervisory authority. And while that sounds general in nature, and it is, basically what we're talking about is supervising a person's relationships, interactions, to make sure they're not being taken advantage of. This power would give guardians the right to sort of supervise a person's social media activity, um, supervise what's going on with them, like in school or a transition program, to make sure that every one of their relationships um, is going along fine, and they're not being put at risk uh, in certain circumstances. And so again, I'm going to expand on this a little bit later, because right now the focus is on what a person cannot do. We're looking at the powers of guardianship, and we're saying we need guardianship because this person cannot do A, B, and C. As I get along in the presentation a little bit further, we're going to focus on what the person subject to guardianship still can do. And so there's a balance between exercising supervisory authority and allowing the person to exercise their own independence and individual rights, even while under guardianship. But the important thing to note here is that supervisory authority basically means, you can watch out for a person who's subject to guardianship if they're having interactions through social media or through like sort of professional programs, or like I said, the transition program, or through jobs as they get older, or day programs, and just make sure that those relationships are healthy and they're not being taken advantage of. The seventh one on here, the next one on the list, applying for government assistance benefits. This is another big one, of course. You have to look at if a person is going to be reliant on benefits such as Social Security, SSI, or medical assistance, the waivered services in Minnesota. I guess I should say, for those of you who aren't in Minnesota, that's our Medicaid program, is medical assist. It's just titled medical assistance. But what that means is that, a person would apply for these benefits at age 18, because again, with the age of majority, they're considered an independent adult and they are eligible for support through the county and through Social Security, because at age 18, Social Security and the state of Minnesota can no longer take or can no longer assume that the parents are going to financially support the individual. Uh, Legally speaking, mom and dad don't have to at age 18. Something you might want to keep in mind for your other kids who do not have intellectual disabilities, but it applies to anybody who's 18. And so the state or has to evaluate whether this person, based on their circumstances, may be eligible for support to help them live in the community, even if they are still living at home. This is, I'm sure, something that last week's presentation, for any of you that attended that, regarding financial planning and benefit planning, really delved into. So I'm not going to get into it too much here. But the point is that unless the person is under legal guardianship, the Social Security Administration and the Department of Human Services for the state of Minnesota will expect that that person is filling out their application and going through their interviews, and then ultimately handling their benefits on their own. And so if the person is incapable of doing that, you need to have somebody appointed with the authority by the court to legally manage those benefits. Now, where this gives guardians some limited financial authority is that if Social Security declares that the guardian is going to be the representative payee, for those of you who are unfamiliar with that, when somebody is granted benefits from Social Security, they can either handle those benefits themselves, or they can appoint a representative to receive the deposits and manage the account where those deposits are made. So it's like a power of attorney of limited scope that's granted by the federal government, and not necessarily by signing a document from the individual. So when a legal guardian is appointed, they're granted with this authority to apply for the benefits on behalf of the individual and then manage those benefits once they are approved. So the Social Security Administration will appoint one of the guardians, and it does have to be one, even if both parents are serving as co-guardians. It will appoint one of the guardians as the representative payee. And so then they set up a bank account where the Social Security deposits can be made. And then the way to sort of, not necessarily cheat, but the way to use this power to manage other assets is if the person, receives like birthday money or some small income or wages, you can deposit that money into this same account where the Social Security checks are going. And then the authority granted by the Social Security Administration to manage that account will extend to all of the other assets in that account. So that's why a lot of people who are subject to guardianship and have not acquired assets independently may not need a conservator or may not need any other authority to manage financial assets if the guardian sets that up properly. But the next power is acknowledging that a person subject to guardianship may have assets. And if they do have assets and they're on SSI or they're on medical assistance, they may have asset limits that they have to maintain in order to stay eligible for those programs. One of the ways that we can keep a person eligible for those programs is by using an ABLE account. And ABLE is an acronym. It stands for Achieving a Better Life Experience. And this is an independent financial account where the person's assets can be preserved, saved, and used for what they call qualified disability expenses. And as long as they are held in this ABLE account, which is set up through a federal agency, and again, that's a topic that last week's presentation with Roger Streggy would have covered in more detail. But once it's established and assets are moved over there, they are excluded from the countable assets in the test for the person's eligibility. What the guardianship statute in Minnesota provides is the ability for a legal guardian to establish the ABLE account on behalf of the person subject to guardianship. But to manage the account, that's going to take another qualification or appointment. Presumably when there is an ABLE account, the person will manage it themselves. That's the idea. Achieving a better life experience is based on this person is semi-independent or higher functioning, and while they still need some of the protections of guardianship, they should still have some limited ability to manage personal assets on their own independently. And so that's something to evaluate for each individual. But the point here is that guardians do have some limited power to assist with that. And then the last authority, representation in court proceedings. This just means that a guardian will stand in as a proxy for a person if there are any civil cases, any situations where a person subject to guardianship is named as a party to a lawsuit, the guardian can be their sort of representative in that case. This does not mean the guardian assumes responsibility for any actions of the person subject to guardianship, any criminal actions, any financial delinquency, anything like that. That burden or that consequence does not get shifted to the guardian just because they are acting as a representative for the person in those court proceedings. So I think, Sue, this would be a good time to, if you have any questions. Oops, didn't mean that.
We do have questions.
Okay. Then go ahead.
Is a conservatorship power of attorney?
Is a conservatorship power of attorney?
Mm-hmm.
Well, the authority that a conservator gets is equivalent to the authority that is granted to a conservator of the estate. The difference is on how they were granted that authority. Is basically as a conservator or as an attorney in fact, which is what we call the person under the power of attorney. Their ability is to transact on behalf of the other person, to manage assets, just like the individual would. The difference is that with a financial power of attorney, that is something that is granted by the consent of the individual when they have the capacity to do so. Conservator is appointed only if this person lacks the capacity, has existing assets, and needs somebody, and there is no power of attorney that was signed previously so that somebody can take over the authority. So conservatorship is something that is done as a reaction to somebody having assets and most often losing the capacity to manage them. And then the third element being that they did not execute a power of attorney when they had the capacity to do so. So we do look at that as a less restrictive alternative to conservatorship. Certainly try and do it as part of estate planning. But if a person is more independent, even with a diagnosis of disability, it may not rule out the idea that they can execute a power of attorney. The issue, though, that in reality that we've run into with banks and fiduciaries, and even in transferring like real estate property, because parents might leave like ownership of a home to their child, and we'll try and use power of attorney to get it transferred, is if you pursue guardianship and there is a court order granting the guardian, that court order necessarily has to find that the person was incapacitated in order to grant the guardianship. We've had a lot of banks point to that finding of incapacity to explain why they will not accept a power of attorney executed by a person subject to guardianship. So it is something that we do look at closely and determine what are the circumstances. Is conservatorship appropriate, or can we still use a power of attorney? But at the end of the day, the authority that is granted in a conservatorship is equivalent to the authority that is granted by a power of attorney. It's just a heck of a lot cheaper and easier to do a power of attorney. So for any of you that are parents, or any of you out there who have not done your estate planning, that's kind of my public service announcement. Make sure you get stuff like that in place before you age, or before you become, before you decline in capacity yourself, because it will make things easier for the rest of your family.
Very good. Next question. If cognition is age appropriate, but the person has a physical disability with medical conditions, would a power of attorney and health directive be acceptable or enough?
Yeah, I very much think so. If a person is physically disabled but has no cognitive or intellectual incapacity, I would say that guardianship is not necessary at all, because that person, just like myself or yourself, Sue, we have the capacity to execute a healthcare directive. We have the capacity to execute a power of attorney, but also we have the capacity to make our own decisions and take responsibility for that. So guardianship is not automatic, just because a person is defined as a person with a disability. It has more to do with whether they can make informed decisions and take responsibility for those decisions. And so if a person has a physical disability but cognitively is capable, then absolutely I would suggest using a healthcare directive or power of attorney if they felt like they needed to give somebody consent to assist them with decisions.
Okay, a statement, a couple of sentences, and then the question. My son's primary asked me when he was 10 what I thought about guardianship. I did not get it then. It was overwhelming. But now as the journey continues, glad she did, so I can learn over time and not have that overwhelming feeling of child versus adult and have it all come up without me knowing about it. However, curious, when do we do the paperwork, etc.? Is it when ending age 17, after 18, or on their birthday?
Yeah, that's a great question. That's one I get often, and it does kind of lead into the next slide, but I assume we probably have other questions still, right?
We do.
Yeah, and so just I'll briefly say, the age of majority thing gives the petition legal standing, right? Because if you petition the court when your child is 16 years old in anticipation of needing a guardian at age 18, the court says, well, there's no standing to grant this petition because this person is 16 years old. they don't have any individual rights at this age that we need to transfer to a legal guardian. So the idea is that you petition for guardianship as close to the 18th birthday as you can. Now, if the need for guardianship is clear and there are no objections to the petition, like you don't have any competing interests for whatever reason, the courts in Minnesota at least are flexible in terms of, like, if we submit a petition maybe 4 months ahead of the 18th birthday, we get a hearing date prior to the 18th birthday, they'll still grant the petition if the person is still 17 years old. But there is somewhat of a limit to that. This is what I mean about it. It sort of leads into the next slide, but the procedure itself, from the filing of the petition to the court hearing, is a process that's going to take about 6 to 8 weeks, and that's usually based on the court's calendar, because we'll file the petition, court will look at their next available dates. That in most districts is probably going to be about 8 weeks out from from when we filed. So you use that as sort of a gauge of when it's appropriate to begin the process. So we usually look at it as about 3 to 4 months prior to the 18th birthday is appropriate to have the discussion, determine that a petition is appropriate, get that petition filed, and then we'll get a court date by age 18. If the court hearing happens after the person turns 18, that's usually going to be okay. If you show a school or you show a doctor or anybody that you filed the petition and the procedure is, you're in process and you're simply waiting for the court date, most authorities are okay with that, because they assume guardianship is going to be granted. There's not a problem with a little bit of an overlap there, depending on the situation, of course. But as a rule of thumb, if everybody knows that guardianship is going to be necessary for a person turning 18, start thinking about it, about the process, about engaging a lawyer, about starting the paperwork, maybe about 5 or 6 months prior to the 18th birthday, to make sure that you can get through the process and get a hearing date as close to the 18th birthday as possible.
Thank you. Next question. I've been unclear as to what the difference is, or even the legal importance of a vulnerable adult designation. Could you explain how that relates to guardianship?
Yeah, well, a vulnerable adult designation, I suppose, are you talking in terms of it's a label that's applied to a person? Like Social Security or the county has declared the person to be a vulnerable adult. It's really more of a description, I suppose. We're looking at somebody who, if they were left to their own authority, so to speak, would they, based on their diagnosis, their medical condition, would they be naturally vulnerable as an adult? Again, can they take responsibility for their actions? Can they appreciate the consequences or the results of their decisions? And if not, they can be considered to be a vulnerable person. And so that's what we're looking at, is on a totality of the circumstances, all of the information, the evaluations that are available to us, do those say that this person, if they are responsible for their own decisions, would that make them vulnerable in the community?
Okay, a couple of questions, and we had a couple last week as well about age and granting permission and access to medical records. I thought that at age 12, children had to grant permission and access to their medical records. I feel like that was the case for us with Alina and Fairview when each of our kids turned 12 or maybe 13. Is this different from when a child turns 18?
Yeah, so my understanding of that is that those are not statutory regulations. Those are not rules created by state or federal law. Those are more policies by those independent insurance companies, private insurance companies. 18 is the state and federal standard. 18 is when HIPAA privacy rights apply. Now, I think if there's concern about that, you probably want to ask people at Alina or at whatever private insurer is requiring the permission of a 12-year-old to disclose that. But as far as we're concerned, from the state law perspective, is that a person who is 15 or 16 years old is still not a legal adult, is still not a person with individual rights such as that, making independent decisions. And so their incapacity is their age. And so private companies can make their own policies, but as far as in the context of guardianship, people don't have that authority to make those independent decisions about their health care until they reach age 18.
Okay. What if parents are divorced and both are fighting for guardianship? How is it decided?
Yeah, also something that I'm going to address later. So I think for the
Okay.
purpose of moving along, we'll save that.
Do I need an attorney when I file for guardianship of my child?
You know, uh, the question of do I need an attorney comes up all the time in all sorts of different contexts. I sort of respond to that with it's like, do you need a mechanic for your car, right? Everything that we do as lawyers can all be done by individuals. You can represent yourself in court. You can, all the statutes, all the federal laws, all the tax laws, all of the law or all of the rules regarding Social Security, medical assistance, they're all out there. They're all available. This isn't private exclusive knowledge that we have. It's just that we've spent time learning it and understanding it. We know the procedure. We know how to do this efficiently. And the way I look at it is this is a significant moment in this person's life. Evaluating their individual rights and going through the process to obtain guardianship. And so you want it done right, I guess, is my selling point for hiring an attorney. But it's sort of like if you can pop the hood on your car and you know how to change the spark plugs, if you know how to fix the carburetor, change the oil, you don't need to go to a mechanic, right? You can do those things on your own. But do you trust that you really know what you're doing? Do you feel confident that you're going to do it correctly? And that's the argument that I make to say, yes, you should have an attorney because this is a significant procedure, a significant moment in that person's life, and you want to make sure that it's done correctly. I always tell people, our goal is to make the hearing anticlimactic, which means that we have met all of the statutory requirements by filing the paperwork correctly, by providing the court with the correct information that they are looking for, so that when we get in front of the judge can look at the case file, see that basically we've checked all the boxes. We've provided them an explanation as to why guardianship is appropriate. We've provided them an explanation as to why the petitioner or the petitioners are the most suitable people to be the guardians. And because of that, there's no question about what action the judge can take at the hearing. And so our goal is that at the end of the process, the hearing lasts about 5 or 10 minutes, because there's no question that we've met all of the requirements for the judge to feel comfortable about granting an order that takes away this person's individual rights. So, yeah, I guess that's a long answer to that, to say, yes, I recommend that you get an attorney because the process is complicated and you want to get it done right.
Okay, we have more, Joe, but I think we should move on. So you
Okay.
have a chance to cover everything you'd like to.
Yeah, and we may reach or we may address some of those things as I move on here too. So we'll see. But yeah, I know we're going to be a little bit limited. We've already eaten up the majority of the time, but that's what always happens. I know I intend for that first slide to be the most cumbersome, provide the most information, because again, evaluating each of those powers of guardianship, understanding what they do, that's the key to determining whether guardianship is appropriate for the individual. So it's really important that that is understood. Oops. Sorry. So the next slide I have here is just to go through what the procedure actually is. So again, we start with the consultation, determining what's most appropriate, and whether there are any less restrictive alternatives that we can pursue in opposition to guardianship. But if we decide that guardianship is necessary, we file the petition. And again, the petition is going to state why guardianship is necessary and why the people who are nominated to be the guardians are the most suitable people for that role. And often that is the parents. It may be brothers or sisters. It may be a cousin. It may be a professional. We're just looking at what is in the best interest of the individual who is subject to guardianship and whether that person is the most suitable to be the person who makes decisions for them. To support the petition, we often will acquire a statement from the person's doctor. We usually like to get the primary care doctor, especially if they have been with them for a long time, to provide us an accurate diagnosis, because otherwise it's just like the parents who are saying in the petition, oh yeah, my child has autism, or my child has Down syndrome. Well, the physician statement would provide backup authority for that, proof of that. The physician does not have to appear in court to testify to that. We do typically just accept the statement for the truth which it contains. Nobody objects, and then it's part of the court file to support the need for guardianship. To help with that, the court also sends out what they call a court visitor. Court visitor is a social worker employed by the court who will interview the person who is potentially subject to guardianship and make an independent evaluation of the need for guardianship for the court. And so they conduct an interview. Nowadays, it's usually done by Zoom. But they can visit in person. They will just kind of go through the petition with the person. Mom and dad, if we're talking about an 18-year-old, they can be present for this. The court visitor would like to, maybe sit at the kitchen table while mom and dad are in the living room, and try and conduct their interview as best as possible. Again, these people are social workers. They they are very experienced. They understand the circumstances they're dealing with. And so if the person just doesn't understand at all what's going on, doesn't have the capacity, or maybe is nonverbal, that's what the court visitor is going to report. And they're going to make a recommendation that guardianship is appropriate. That becomes part of the court file and something that the judge can evaluate in making their ultimate decision. In order to protect the person's individual rights through this process, because that's what we're talking about here, is having those rights removed and granted to the guardian, they do get a court-appointed attorney. This happens automatically in our larger districts like Hennepin County, Ramsey County, Dakota, Anoka. Well, I'm sorry, I should back up on that. Not Anoka necessarily, because that's a good example. In some districts, especially outstate districts out of the Twin Cities metro, there's just simply not a lot of attorneys practicing in those areas. And so the court relies on the visitor to do their interview and then recommend whether this person needs an attorney or not. Again, if the person is nonverbal, if they're completely lacking in understanding what's going on and guardianship is absolutely necessary, the court may decide to waive the need for a court-appointed attorney. But like I said, in districts like Hennepin County, Ramsey County, Dakota County, that's going to be an automatic for the individual. Usually the court-appointed attorney is mostly just along for the ride. You know, if there's no objection, if there's no need to hammer out any details, they're going to accept the guardianship for what it is. They will tell the court there is no objection, and they won't have a whole lot to do with the case. All guardians are subject to a criminal background check. Guardians who are not parents will have to resubmit their consent to a background study every several years, and that does vary a little bit by the county. It can be anywhere from like 2 to 5 years. You have to resubmit your consent to a background study. If the parents are the guardians and the person has always lived with their parents, at the hearing, we can have the court waive the requirement for background studies. But just something to be aware of for people who are not parents who are seeking guardianship. You're always going to be subject to a background study. There is an educational video that kind of goes through all of these details and points. This is required viewing for people seeking guardianship in Hennepin and Ramsey County. It is not required in the rest of the state, but it's still a pretty good idea just to go through and get an understanding. This can be found on the Judicial Branch website. It can also be found if you just plug Minnesota guardianship video into Google and follow it there. It's about a 25 to 30-minute video. A lot of parents do find it helpful because it sort of distinguishes between your role as mom and dad and your role as agent of the court in being appointed to protect this vulnerable adult in the community, and what your requirements are, ongoing requirements to the court. The court hearing I touched upon briefly. Again, you know, if it's an uncontested case, we are still held to our burden of proof, but it's not terribly difficult to meet that standard. We just provide some testimony based on why the powers of guardianship are necessary. You know, if it's a lot of times when we'll have hearings in other districts outside of the Twin Cities, smaller districts kind of like to keep things moving because their judges are going to be assigned to multiple cases a day. A lot of them are higher stakes, of course, than an uncontested guardianship. So they'll look and they'll check the court file, see that everything has been filed properly, that we have met all of the statutory requirements, and if there are no objections, they may simply grant the petition without any testimony. But still something that is required to be done. We have to attend that. I will just skip over real quick and come back to the cost, but the annual filing requirements are something that you learn in the court hearing or in the educational video about a little bit more. Again, when, say, for example, mom and dad are appointed as the guardians of their child with a disability, they are no longer, you sort of have to flip your head to understand you're not just mom and dad. You've been appointed as agents of the court to protect and assist this vulnerable adult in the community. That's why this court procedure is necessary. And so in order for the court to maintain their supervision, you've got to file a report letting them know how things are going. So every year you, on the anniversary of the court hearing, basically the appointment date, you've got to file what's called a personal well-being report and essentially inform the court how things have been going, how often do you see the person subject to guardianship, has anything changed? It's a form that is prepared by the court. There is a portal system on the judicial branch website. You get all of this information post-hearing from the court, informing you on how to complete your filing requirements. But for now, just something to be aware of, that you have to get those done. If you do not, the court starts worrying, what's going on? Is this person safe? Do we have to take action to protect them? So parents who forget to meet their annual filing requirements will get first a notice from the court, and then that escalates as time goes by. If you continue to disregard the court's notice and the filing deadline, and ultimately it can result in the court sending the sheriff to do a well-being check on the person. And so you don't want to get to that level. So the point is, just make sure you understand and meet your filing requirements. The renewal requirement is somewhat new. We have not fully engaged it yet, but what it says is that, or what it means is that for anybody who's under the age of 30 when the guardianship is granted, the state law in Minnesota as of August 1st of 2020 says that guardianship has an expiration date on it. It has a maximum duration of 6 years, 72 months. And so the idea is that, it kind of goes back to what I said at the very beginning. A lot of 18, 19, 20-year-olds aren't mature enough, aren't ready enough for independence, regardless of, diagnosis or not. The court acknowledges that, or more accurately, the legislature acknowledged that, to say that, if a guardianship is granted for a person who's under the age of 30, we should reevaluate that after 6 years, after they've had some time to grow, after they've had some time to become more of an adult, and determine, is guardianship really appropriate? So at the end of that 6-year term, we're going to be required to file another petition if the guardianship is still appropriate, and state that this person has Down syndrome, their capacity has not improved, they still are a vulnerable adult at age 24 or age 28 or whatever they are. And at that point, the court can grant an unlimited guardianship, or a guardianship unlimited in duration. Doesn't mean that guardianship cannot be terminated. It would just mean that there has to be a finding that the person is now capable of independence. So we just look at it from that perspective of, if we're granting guardianship for a young person, let's reevaluate this after a few years, determine whether their capacity issues were due more to age and just, having just being a little bit behind, like their classmates or a typical 18-year-old or 19-year-old, and whether as a person in their mid-20s, they're more capable of independence, or whether their diagnosis prevents them from ever reaching full capacity as an adult. Okay, and I'll just go briefly back to cost. All of this, of course, costs money, whether you do this on your own or whether you do this with the aid of an attorney. When you file a petition with the court, there is a filing fee. If there is a court visitor, if there is a court-appointed attorney, they're going to expect to be paid. And so when we file a guardianship petition, we're evaluating whether the individual themselves has any personal assets that can afford this procedure. We're not looking at mom and dad, we're looking at the individual. What is in their bank account, and can they afford to pay the fees? If they cannot, we file a separate petition for what's called informa pauperis, and that's Latin for this person doesn't have any money. And what it does is, if the court grants the petition for informa pauperis, we refer to it as IFP, they will cover the expenses that are allocated to the individual. So the county basically then covers the filing fee. The county covers the fees for the court-appointed attorney, the court visitor. So this is where you get sort of mixed messages. A lot of people, who work in support, maybe case managers, social workers, maybe even the organizations may say, like, oh, guardianship is free. You shouldn't. It's not free. It's never free. It costs money, but if you apply for relief, you can be granted relief for a lot of those expenses from the court. Now, in a lot of districts, there are some districts that pay the attorneys for the petitioners. And so that works out. Anoka is one of those. Washington County does that, where they pay sufficient compensation to the attorney who is representing the parents. Many other counties do not do that. So do not be surprised if the attorney says we charge a separate fee for to represent the petitioners in this process. We do that. We try and we keep it as modest as possible. But the idea is we've got to cover, our expenses. We've got to pay our staff for producing the documents. We've got to cover our appearance at the hearing. And so for that, we do ask for a separate fixed rate fee, as well as applying for the relief from the county. So just something that you can keep in mind. Each individual attorney or law firm is going to have different rates for that, or possibly a different philosophy. But just understand that if you hear that guardianship is free, that's not the case. It's a matter of determining what kind of support or relief we can get from the county and what we need to ask for from the clients to cover the rest of our expenses. Because quite frankly, if I'm going to be a little defensive about that, it's if we don't have if we can't be paid to cover our expenses, we just simply can't offer the service, right? We're not funded by the state, we're a private business. And so that separate payment helps us to provide the service to people in those districts where the county does not provide that compensation for you. All right, Sue, do you want to maybe ask a couple more questions now?
Sure, we have a lot. So let me
Okay.
just pick a couple. What if you live in Minnesota, but a different state has jurisdiction? Where do you petition? In the state you live in or the state with jurisdiction?
The state where the individual, the person subject to guardianship, where they live is what is the deciding factor. That's what it comes down to. The guardians can be anywhere. Then it's just a question of, are they the most suitable guardians? You know, can they manage their duties from somewhere else? But if you are a person who, say, has, or if your family has moved here from, say, Colorado, you know, guardianship was established in Colorado, you've now moved here to Minnesota, you do need to change the jurisdiction on that from Colorado to Minnesota, and there is a process for that. We have a handful maybe every year. You know, people move around, and the guardianship is portable, but if you are not living in the district where the guardianship was granted, eventually that district, especially when you are making your annual filings, they will declare that they no longer have jurisdiction over this guardianship. And if you're not in the process of transferring the guardianship to the new jurisdiction, they may simply terminate your authority as guardians, because they will say, we lack the jurisdiction to continue supervising this individual. We're going to terminate the guardianship for cause. So be aware of that if that question is based on moving to Minnesota from another district or another state, you're going to have to go through a process to get that transferred, or you risk having the guardianship terminated by the home state. But ultimately, it does only matter where the individual subject to guardianship is a resident, and that's where they determine jurisdiction, not where the guardians live.
Okay, let's move along, Joe. I want to make sure you
Okay.
cover everything.
All right. Yeah, and so, you know, as we're going through that court procedure, there are some special considerations. You know, we've gone through all of the powers of the guardian. One of the things that we have to address is whether the person subject to guardianship should retain their right to vote. This is something that the courts want to preserve, right? That the idea is that we're only going to take away the person's right to vote if they absolutely are unable to understand anything about it, and make any kind of a choice whatsoever, right? So we're talking about individuals with more profound disabilities. Of course, we are worried about the risk of a guardian using their influence, or but you know, you can kind of say that about any situation. You know, people are subject to their environment to determine how they're going to vote. So there is a little bit of that concern, but otherwise, the idea is that we are going to protect a person's right to vote, even if they are subject to guardianship. So I would say that in a good majority of the cases where we pursue guardianship, we still do preserve the right to vote. Because if the person does go to a polling place, Secretary of State does provide accommodations, does educate the pollsters, the people working at the polling places, on how to provide accommodations and help a person if they have special needs going in to cast their vote. And the guardianship order will say explicitly that the person retains their right to vote. So if you have somebody who is subject to guardianship, you take that order with you to the polling place and show it to the election officials, and they will allow the person to vote. We did cover the power that the person has, or the guardian has the ability to make medical decisions, see medical records. That doesn't automatically allow the guardian to give consent to experimental or extraordinary medical procedures. For that, there is a higher standard. What we're talking about here are things like sterilization, electroshock therapy, things that would be out of the ordinary course of, medical support. And so if something like that is considered for the person subject to guardianship, the statute does require that the person then petition the court for an independent evaluation of that decision and provide at least 2 statements from separate doctors agreeing that the procedure is appropriate. So just something to keep in mind, that power to make medical decisions for the legal guardian does not automatically extend to more extraordinary medical procedures. The Bill of Rights for persons subject to guardianship or conservatorship is important. I sort of alluded to this before. I do have a couple of slides here, and you guys will be able to have it in your materials. I'll show you quickly, and then I'll kind of go through. But the legislature does consider the idea that if we are talking about all the things that a person can't do, we want to look at all of the things that they still may do if they are subject to guardianship. And so that's what the Bill of Rights is all about. And a lot of it is sort of fundamental. They have individuals have the right to participate in their decisions about where to live, about how to handle personal property. But then also, retains the right to petition the court to terminate the guardianship at any time, has the ability to ask that, a different guardian be appointed if that's appropriate. Of course, they would have the burden of proving why the guardianship is not appropriate at that time. But it does. The emphasis here is just to remind you that the person subject to guardianship does retain individual rights, even though they are subject to those other powers that the guardian has. And here is where I mentioned before, we have what we're going to do in the case of divorced parents. It is not unusual if the parents are amicable, if they get along, that we could have divorced parents appointed as co-guardians. One of the things that the court stresses is that they will not adjudicate the divorce all over again in the guardianship. Basically, if a person if both parents have retained parental rights, the court, that was determined by the division called the family court. Guardianship is determined by the probate court division. And so the probate court basically declares we are not going to issue a ruling that's going to disrupt or contradict the ruling of the family court as far as parental rights are concerned. So divorced parents can be co-guardians. The trick is that under the guardianship statute, co-guardians have to make all decisions together. They cannot act independently, like when, their son is with dad for the weekend, it doesn't mean dad is the exclusive guardian that weekend. The son is with mom, the next week, mom is not the exclusive guardian. If the person subject to guardianship has to go to the doctor, or if there is a meeting with the school or at their job program or whatever is going on where it requires the decision of a guardian, both co-guardians have to be involved and come to a unanimous decision on those issues. If parents are divorced and they don't think that they can work together, one parent can consent to the other parent being the sole guardian. Again, it doesn't mean like if dad gives the consent to mom being the sole guardian, doesn't mean that dad loses parental rights. But now mom is the sole decision maker with regards to medical decisions, where the person lives, dealing with benefits, all of those things. If the parents cannot get along and cannot come to decisions unanimously, what the court is looking at is what's in the best interest of the person subject to guardianship. So if divorced parents cannot coexist as co-guardians, more likely than not, what the court is going to say, court is not going to pick a favorite unless there's a significant issue, like one parent has, you know, significant like criminal history or has abusive past or has issues with drugs or alcohol. While the court can then say that person is not suitable to be the guardian, I'm going to appoint the other parent. But if it's just a matter of disagreeing and a bad relationship between mother and father, the court's not necessarily going to pick a favorite between the two. In most of those cases, the court is going to say, okay, you're both out. Neither of you can be the guardian. We're going to find a third person, whether that's going to be another family member or whether that's going to be a neutral professional, because we are not concerned about, the parents' rights here. We're concerned about what's in the best interest of the person subject to guardianship. So again, just to touch briefly on this, the Bill of Rights for a person subject to guardianship, and you can evaluate these on your own. It's just good to remember that a person does retain individual rights. One thing that I would like to point out, though, is number 11, very briefly. I often get calls from parents who are worried about their child who is now in their 20s or 30s, who has entered into a personal relationship and wants to get married. And the parents say, well, we're guardians. We can stop that. And the reality is legally, no, you cannot. Now, with an asterisk to that. Now, you see above number 10, where I have in parentheses and an asterisk about communicating, interacting with others, unless the guardian has good reason to believe restriction is necessary because that interaction or that relationship poses a significant physical, psychological, or financial risk. So that is the standard that a guardian can employ to basically interfere with their person's right to marry. But otherwise, you should understand that, like if mom and dad are the guardians and they don't like the person that their daughter is planning to marry at age 30, that doesn't exactly make you unique, I suppose. That's a story as old as time, mom and dad not liking the guy that their daughter picked. But just because you are guardians does not mean you can put your foot down and stop that marriage. You have to have a real good reason to interfere and state that the person subject to guardianship is being put at significant risk in this relationship. Okay, and then this is my last slide, and I just here address some of the things that we can do as alternatives to guardianship, and I've sort of touched on these throughout, but a limited guardianship goes back to those individual powers of guardianship. And that means, again, we can isolate and pick and choose which of those powers are appropriate. So the ones that we leave out would mean that the person subject to guardianship still retains the legal authority to exercise those rights on their own. So an alternative to full guardianship would be to limit those powers. And a lot of times we'll limit the powers to like making medical decisions, managing government benefits, maybe even choosing the place of abode, choosing where the person lives, but leaving the person the right to manage their personal property on their own. allowing the person to take care of their own comfort and maintenance needs, allowing or not exercising any general supervisory authority over the individual in terms of their relationships or how they're dealing with like a job program or employers or anything like that. So something to consider when we have the consultation is, are all of the powers of guardianship absolutely necessary, or can we limit the guardian's authority to preserve independence for the person subject to guardianship? And then, as I touched upon earlier, the healthcare directive, the financial power of attorney, these are ways to that a person who may be vulnerable can give their consent to somebody else to act on their behalf, assuming that they have the capacity to do so. If they do not have the capacity to do so, that's when we pursue guardianship. Supported decision-making, technology assistance, these are things that you can seek out to determine whether less restrictive alternatives are possible or whether guardianship is actually necessary, because there are a lot of programs out there. Sue has provided them in the list of resources to some extent. There are places like, Gillette will provide people with technology assistance. Volunteers of America provides some really good information and access to support. And then if you look at that website, Disability Hub, and I think, if I'm right about this, Sue, I think Pacer provides some of this information on its website as well um, about options and ideas to provide support to an individual to live independently without guardianship. And so those things can be evaluated and determined whether they are going to be sufficient to help a person live independently as an adult before we choose the option of guardianship.
Joe, I'd also like to put a plug in for Pacer's Simon Technology Center, where we can help children, youth, young adults, families figure out what kind of tech is out there and what that student might need. You can check out tech. Just go to our website and look it up. It's a really great resource.
Good. Yeah, I fully endorse those things. Explore the options. And that's why I call guardianship sort of our option of last resort. In a lot of cases, it's going to be obvious. Person is profoundly disabled, nonverbal. We know that technology assistance isn't going to override the need for a substitute decision maker. But if a person is on the autism spectrum, if they have a intellectual disability that allows them to be somewhat independent, it's worth exploring those options and seeing what might be an alternative to guardianship. So that gets me through all my slides. I know we're a little bit late here, but for those of you who have stuck around, I'm happy to try and answer some questions as quickly as possible here. So I appreciate everybody who did stay through the whole presentation. Thank you for your time. Thank you for listening. And for those of you that are watching later, thank you for hanging in there for a long presentation, and hopefully provided you some helpful information tonight. And Sue, if you want to fire some questions at me, we'll see if we can cover as much as possible here.
All righty. What happens if a guardian dies or is otherwise unable to carry out the duties assigned to them?
Yeah, so we would have a petition for a successor guardianship, to have a new guardian appointed. That process would be the same as the original process. So a lot of times we will have clients as parents who are getting older, who will perhaps appoint like another one of their children as a co-guardian just to cover that potential eventuality. that something might happen to them where they are all of a sudden no longer able to be the guardian. This will happen sometimes when we have two parents as guardians. The first parent passes away. The surviving parent might appoint another co-guardian for that purpose. But if something happens unexpectedly and there is not a guardian in place, then we determine, does the person need a guardian right away, or is there enough support in place where we can kind of take care of them for 3 or 4 months while the normal petition and court process plays out. Many times that is possible, especially, you know, if you've got somebody living in a group home, they've got like PCAs, they've got support individuals around them to kind of, and like doctors may be understanding of say, okay, you know, for this brief period, we'll allow like your brother to help you with your appointments and your prescriptions, as long as we know that there is going to be a successor appointed. If that is not feasible, if the idea of not having a guardian appointed for say 4 months or 6 months is just too extreme, puts the person at too much risk, we do have a procedure in the statute that allows us to appoint an emergency guardian if we can show significant imminent risk to the person. And if we file a petition for emergency guardianship, the court is required to hold a hearing on that petition within 5 days. And what they will do is they will appoint the emergency guardian for a period up to 90 days, giving us the opportunity in the meantime to file the petition for unlimited term guardianship.
Okay. If our son grants us power of attorney for finance, healthcare, or both, would the school honor the POA and allow us to attend IEP meetings? Or would the doctor allow us to help make decisions if needed?
Yeah, the answer to that is it's up to the school or it's up to the doctor. And oftentimes that's when you find out whether guardianship is necessary or not. Because if you present them with a power of attorney, or if you present them with a healthcare directive stating that you have the authority to make decisions, they will determine whether your son or daughter had the capacity to give that consent. Did they understand the authority that they were giving to mom or dad in that document? If it's accepted, great, that's wonderful. Continue using that, you know, and you know, you've just saved yourself a lot of trouble with the court system, you know, of having to go through that process because you found a less restrictive alternative that is sufficient because it's acceptable. But the true answer to that question of, you know, is that going to work, is I don't know, because it depends on who you present it to and whether they decide they can accept it or not, because now it's a question of their own liability. You know, if your son executes a financial power of attorney without really understanding what that does, and then you go and, you know, just for example, you access his bank account, you withdraw money from it. Next time he goes to the bank, he finds out that you did this for whatever reason. And he says, what were you doing? I didn't allow you to, you know, take money out of the account, you know, saying this to the bank. Now you've got an issue of liability of concern. I suppose these are just, you know, examples trying to get to the point of the place where you are presenting the documents is going to determine whether they are acceptable or not. So that ultimately is going to determine whether those less restrictive alternatives are viable for you.
Okay. For an individual who's capable of most decision-making but does not have the understanding or capability to make financial decisions, what are the options for protecting them from being preyed upon financially?
Yeah, you've got to look at, you know, if you're protecting assets is the representative payee account that you have through Social Security enough to protect those assets? Is an ABLE account going to be appropriate? Perhaps using a trust with a trustee would be appropriate for the person. But ultimately, you know, it's just like anybody else. You know, if I'm 22 years old and I'm not very mature, and you know, somebody comes up to me on the street and says, you know, hey, I'd like to you know, sell you my shoestrings for $20. Give me that $20. If I turn over that $20, well, law doesn't protect me from making that decision. So you've got to make a determination of, is this person's vulnerability due to their diagnosis? And if it is due to their diagnosis, then what options do we have? If executing a power of attorney is a possibility, you can do that. But then also looking at an ABLE account, a trust account, different ways to protect a person. And then with the ultimate protection being the person basically forfeiting their independent financial rights with a conservatorship.
Okay, we've had a couple questions about revoking guardianship that was established when the person was 18. And then it seems like later in life, they're able to make decisions for themselves.
Well, the authority of the guardians does not change unless somebody petitions the court to declare that the guardianship should be altered to give more rights back to the individual. Now, the guardians themselves can make a determination. You can kind of slack off, especially, you know, parents, family members. You know, it's like when we're talking about like taking care of personal property, when we're talking about personal relationships, you know, as the person gets older, you can maybe just, you know, back off on your enforcement of your authority, choosing where the person lives, those kind of things. That's a way to sort of soften the powers of the guardian. But if you're going to revoke any powers of the guardian legally and return those to the person subject to guardianship, aside from the expiration date that I talked about before, but the burden would then be to show that things have changed. You know, basically the person subject to guardianship has progressed to a point where they are capable now of taking responsibility for those decisions and being independent when it comes to certain aspects of their life. So the person subject to guardianship has the right to petition the court for that. The guardians themselves could petition the court to say, we think that the guardianship could be changed. But again, you now have a burden to the court to establish what has changed and why the court should reevaluate the guardianship powers that they've given to the appointed guardians at that time.
Okay.
So
I had a question about accessing the resources that were posted in the chat, but someone said the chat was turned off and they weren't seeing the resource list.
oh, that sounds like a Jamie question.
It is.
They still should see that, the files that I put in the chat, they just can't use the chat to speak with us, but the files should still be there. And if they don't see them, the links to the slide deck and the resources were included in the reminder emails that you received 1 hour and 1 day before this event. And they'll also be included in a follow-up email that you'll receive tomorrow, probably tomorrow night around 8 o'clock. So the several ways to access that.
Okay, what else? Just a reminder to the people who are still participating, you'll also be receiving a link for an evaluation. We would appreciate it if you would complete that. It's really helpful for our funders to know how the training went. So what do you say? We still have more questions, but maybe just take one or two more because it's getting late.
Now,
Let's see. Did that one, that one. On average, how much are attorney fees for parents in the process?
yeah, those can go all over the board. You know, because if you hire a big law firm that's in, you know, got an office in the IDS Tower or something, they may charge a significant amount. I've heard some outrageous, like retainer fees and things being thrown around. But if you're the typical family pursuing guardianship through an attorney that was referred to you by, you know, say Pacer or Fraser or Hammer or Opportunity Partners or one of those organizations, I would say that most of the attorneys that I know, and to be fair, most of us know each other. Yeah, this is kind of a, you know, it's a niche practice. We all kind of try and support each other. Very rarely do we become adversarial with each other. And so we don't really talk exactly what we charge as far as fees go, but I think it would be fair to expect that you're going to be in the range of $1,000 on the low end to 2,500 to 3,000 on the high end to have an attorney represent the petitioners throughout the entire process. And that's assuming that the court fees are going to be covered by that informa pauperis, because those on their own, we've sort of calculated all of the expenses that are due to the individual subject to guardianship. The calculation of all of those expenses comes out to about $1,800. So assuming that there is informa pauperis granted, you're going to have that $1,800 cost relieved, and then private attorneys representing the petitioners might charge in the range of 1,000 to 3,000 for their representation. I would say that's a fair estimate, but yeah, we're all in private business, so attorneys can post whatever they feel they are worth, I suppose, or what they can earn in representing you through this process. So,
Joe, I think this is our last question. And I think it's a really important one. My child has significant developmental and physical disabilities. If when we can't take care of my daughter at home, she will need care at a nursing home level facility. If in such a home or facility, do the parents retain guardianship, or is there some sort of co-guardianship or transfer to an institution?
no, the parents who are the guardians will retain their guardianship authority in most cases like that, unless they decide it's in the best interest of their child to provide some limited powers or powers of guardianship to somebody else. This is if they are institutionalized willingly, right? Or, you know, at a choice, basically, that this is for their best. So we have clients that are hospitalized or otherwise placed down in the mental health support unit that's in St. Peter, the hospital down there, where parents or family members retain guardianship. And that's so that ultimately they can be consulted on all of the medical decisions and other significant decisions regarding that person. Now, they're not going to be directly responsible for the care, comfort, and maintenance, the daily supervision, but you still retain that ultimate authority to make decisions for the person. It does come down to evaluating again what's in this person's best interest, who is going to be the most suitable guardian in that situation. Now, if there is an issue about whether the parents are providing adequate supervision, if the person has to be, like, say, hospitalized based on police orders, like something has happened where they're now being put on what we call a commitment. It would be like a 72-hour hospitalization where the police have ordered this person to be supervised. Then it can call into question of whether the guardians are doing their job of providing this person the correct support, or whether they should, or whether their role as the guardians should be scrutinized and evaluated. Because again, the guardians, when they are appointed, they are agents of the court. It's the court's responsibility to make sure that this person is safe in the community. And if the person is having to be hospitalized or committed against their will, it's natural to question, well, why aren't their needs being met by their guardians? And are their guardians still the right people for the job? They may very well be, but it is something that's going to be evaluated. But again, to get back to the original question, just the action alone of the person being institutionalized, hospitalized, or committed does not automatically mean the guardians will lose their authority.
Okay, I know there's still some outstanding questions, but we've got the ability to track them. And Joe, could I maybe circle back around with you with those?
Yeah, if people want to send their questions to Sue, yeah, what we've done in the past, and this works well for us, is if Sue, you just kind of gather those questions and send me an email. I can write responses, and you can reply to those individuals who still have questions about some specific things from the presentation. Keep in mind, though, I do have to always sort of remind people, I'm not an employee of Pacer. We work independently. And so if you're seeking advice and counsel specific to your situation, that may raise the possibility where I'd ask you to set up a consultation with our office where we are going to likely charge at an hourly rate for that specific advice and counsel. My responses to the questions here and everything related to this presentation is meant to be general in nature. So I will do my best to answer as many questions as you send to Sue, but there may be a point where I'm going to have to address that directly. So just for the sake of making that clear.
All right. Thank you, everyone. Joe, once again, thank you. Another great presentation. Have a good night, everyone.
Thank you.
Thanks, Jamie.